Hello, Patrick. Thanks for coming back again.
Thank you, Jason. My pleasure. Great to see you again.
So I have Patrick Kelleher here, who is founder and owner of Kelleher Elder Care Center, and really appreciate you coming back and giving us some of your expertise. The last time we talked about breach of fiduciary duty. Obviously, there's a lot of issues surrounding around that, but can you just give us a basics of what that is? Obviously, we both understand that term, and you deal with it all the time. But what exactly are they talking about when they're talking about a breach like that?
Right. Great question, Jason. So the legal definition of a breach of a fiduciary duty under the Uniform Trust Code, a trustee or a fiduciary, they have what they call the highest duty of loyalty to act in the best interest of the principal. The principal is the client, typically, the person who's creating their power of attorney, the person who's creating their trust, and so forth. So that trustee has the highest duty of loyalty to the principal as well as the beneficiaries of a trust or an estate plan as well. And if they violate their duty of loyalty and their duty of care to that principal or the beneficiaries, that fiduciary, that person could be held personally liable.
So say if there's some fraud that's going on, that there's whether it's a family member or whether it's a institution, hopefully not institution because they're supposed to be trained and know these things. But say if there's some fraud going on that they're using some of this funds or all of these funds for things they're not supposed to be doing. What are the recourses that an individual has, like the beneficiary has, to combat this issue?
Yep, great question. So beneficiary typically will often be the triggering person who notifies maybe the family attorney, or they ring the bell and they bring this to the forefront if they feel that the trustee is absconding funds or just not managing the funds properly or appropriately. And so the beneficiary sometimes their allegations may be unwarranted. It could be some family drama or a disagreement or poor communication and so forth. So the matter oftentimes requires the attorney to look into it. And the attorney under Rule 1.6, as we know, has a duty of confidentiality, a duty of care, a duty of loyalty to the client. Oftentimes we'll say the principal in that situation. And then you wonder, gee, do we have a duty to the attorney in fact, the fiduciary? Although they're not a client per se, they do have legal authority to step into the client's shoes. So under the NAILA aspirational standards, which is the National Academy of Elder Law Attorneys, Rule 1.14, Rule 1.14 is working with clients with diminished capacity.
Yep.
And then there's a case called Fickett with an F, v. Pima County, where the attorney has, that case says the attorney has a dual duty to make sure the client is being taken care of, but also making sure that their fiduciary is acting in their best interest. So you have to guide the fiduciary, make sure they're doing a good job. And in cases where you have a fiduciary, a more formal fiduciary, like a conservator or a court-appointed fiduciary who might be being what we call a bad fiduciary. They may not be stealing funds, but they might be overspending. They might be paying themselves handsomely, too much funds and so forth. Maybe paying family members of their own in a self-serving way, or engaging in what we call self-dealing overly and so forth. So when you have a bad fiduciary and that beneficiary is now saying, hey, bad fiduciary, I don't like the way things look here, that beneficiary can request an accounting from that fiduciary. I want an accounting. What's going on? I want to see the X's and O's here, the assets and the expenses and distributions and who they're being made to and so forth. So under the Uniform Trust Code, the beneficiary is entitled to an accounting unless the trust states otherwise. But in that situation, the beneficiary can always file a petition in the probate court and have a court order mandating that the trustee produce and furnish an accounting. So that accounting could be a good information for that beneficiary to reveal whether there's any absconding of funds or any misappropriation of funds or any over excessive spending. And long and short of it, from my experience, if you're working with a bad fiduciary, the attorney's job is a very precarious one at that point because you have these dual duties. And so typically you have to advise the fiduciary to basically remedy the wrong, right the wrong that they did, give them a strict deadline, get it done within 30 days, furnish receipts, show me that you cleaned things up and that you paid money back to the estate and so forth. And then the attorney can review everything. And if everything has been done properly, then maybe everything will be good. Give that trustee, fiduciary, or conservator some formal training, education training on how to be a good fiduciary and so forth. But if they don't remedy the wrong, then the attorney might be faced with a situation where they have to make what they call a noisy withdrawal to the court. Okay. And what is a noisy withdrawal? Noisy withdrawal is you're using the least restrictive alternative to bring the matter to the court's attention with disclosing the least amount of information. And it might be just a Rule 1.16 attorney withdrawal. Sorry, Your Honor, I can no longer represent in this matter. And if it's a really bad case, you might suggest to the court that the court appoint a guardian ad litem. And that's called a protective proceeding, a protective proceeding. And if it's really bad, in an extreme case, the attorney may have the option, they're not mandated, but they could report it to Adult Protective Services, APS, Adult Protective Services, to get them involved, and also maybe even law enforcement if it's a fraudulent case and there's substantial financial or physical harm. So Rule 1.61 attaches duty of confidentiality to the client. And this case is also, Jason, where the principal is not the client, but the fiduciary is the client. And the fiduciary is coming to you, the conservator, saying, oh, I messed up on the accounting. I didn't balance the books properly. What should I do here? Now our duty 1.6 attaches to that fiduciary. We still have that dual duty to protect a person, the person with the disability. Even though they're not our client, we still have a duty to protect them as well. And you still might be looking at doing that noisy withdrawal, withdrawing from the case while disclosing the least amount of information possible to protect the protected person. That could include 1.16 withdrawal from representation of services, yep. As well as reporting to Adult Protective Services to protect that vulnerable person, as well as sometimes reporting it to law enforcement as well.
Yeah, I remember last time that when we spoke about that, there's advantages and disadvantages using a professional fiduciary. The advantages of using someone who may be someone that you certainly trust them more, you've known them for longer. But, if there's something that goes wrong, certainly you can sue them. You can also call the police on them. But it's something that So it's very heartbreaking in those situations that we have seen. And also the other issue is a lot of individuals don't have a lot of money. And maybe that was the first reason why they took the money in the first place. And that becomes an issue. While on the other side of things, a professional fiduciary, you may not know them personally, but if they're kind of backed by a financial institution like a bank, you were saying, that there's insurance that they can draw on, even though if that one individual who took the money doesn't have the money to pay it back, there's also a financial institution insurance that would essentially repay the person who was lost the money. So that's a tough pros and cons type of thing for people to kind of go through.
Right. Yep. So the professional fiduciary, such as a trustee from a financial institution, such as a bank, they oftentimes will make a good alternative to folks who might have maybe a sizable estate, maybe they have some financial wealth where their financial bank can manage the money and conduct the assets under management type work to invest the assets and look at longevity, making those assets grow, preserving the assets, and protecting those assets for the future of the beneficiaries, possibly for generations to come, the children, the grandchildren, maybe even the great-grandchildren, right. Type of thing. And so the benefits, obviously, of a professional fiduciary, professional trustee would be, as you mentioned, they are professionally insured with professional liability insurance. Number two, they're professionally trained. And number three, if that trustee is no longer able to serve, you have the whole trust department there. You're going to likely have a successor to that professional trustee step up into their shoes. So you have the longevity benefit as well, where the opposite of that, when somebody picks a family member, yes, the cost is less, but number two, you might have the risk of that professional trustee. And from my experience, could be even a very bright, educated person, but they have zero training on how to be a good trustee. They might even have a good accounting background or good financial background, but their people skills may suffer and be deficient. Right. And a good professional trustee needs to know how to communicate, needs to know how to be transparent. So they're keeping family relations keeping family relations I refer to as in harmony opposed to in harm. So if you have a fiduciary, they might have the technical skills, but if they don't have the skills to communicate with the other beneficiaries, or if they fail to communicate properly, they can create a whole host of other issues. And oftentimes I say to my clients, if you have $500,000 or more, $1 million of cash investment to manage, consider naming a professional trustee, maybe not as your primary trustee of your trust, but maybe the professional trustee serves as a successor, alternate, as a backup. So if you're a lead trustee, if you're Tom Brady, is no longer able to serve because either of illness, incapacity, or death of their own, because they're a human being. We have shelf lives. Unfortunately, they have a professional trustee as a backup in order to be there as a nice sweater in a suitcase to say, we got this. We're going to make sure that your trust and your wishes go as you expected them to go, and that money's not going to be misappropriated or mismanaged.
Yeah, I mean, that's such a good point. There's all these stories that you hear that people come from a lot of wealth or came into a lot of wealth, and they have children. And, the children, you just get used to go asking for mom and dad, or if you make Uncle Pat your fiduciary, the relationship can sour very quickly, right? Instead, you could create a trust. You can have, particular allowance or however you want to call it to those children. And when they go and talk to mom and dad, or when they talk to Uncle Pat, it's not about money because it's not your responsibility. No, the professional trustee won't give it to you because of X, Y, and Z. And it becomes a much more harmonious family because you're just talking about family dinner. You're just talking about Easter. You're just talking about other things that don't have to deal with money that really gum things up. It's not Uncle Pat didn't want to give you the money. It's just the bank. The bank won't give you the money because it's not under the terms that we talked about before. And it really takes the pressure off the family, which it makes a ton of sense to me.
It really does. It takes the pressure off the family. We often say the magic words that the trustee needs to know. The magic word is a simple no to the beneficiary who might be overbearing, maybe overreaching, overspending. There might be a spendthrift trust. There might be a family bloodline protection trust. And the trustee has the legal authority to make distributions for what we call HEMS, health, education, maintenance, and support. And now you have a beneficiary who's has a lifestyle that they're trying to support, and the trustee should not make an additional distribution to them because they just recently made a distribution that was appropriate. And then those beneficiaries oftentimes are very good at putting pressure on that family member, maybe manipulating them and maybe putting a lot of undue influence on them. And so then the family member is faced with a family situation saying, well, if I don't give in to them, if I don't say yes to them, they're not going to love me any longer. They're going to create family feud, a family fight, where the professional trustee doesn't have to worry about that. They can go home at 5 o'clock, shut the light out, and not worry about their family member or that person calling them over the weekend. And the trustee has a strict duty of confidentiality and duty of loyalty to that trust instrument to follow the terms and conditions of that trust, and they follow it to the letter. So that's something that folks should definitely consider. They should do the risk-benefit analysis would be my recommendation. Right. Maybe appoint that trusted, suitable family member as their initial trustee when you have cash assets to manage, and then maybe have your trusted bank trustee serve as the alternate successor trustee as a nice sweater in the suitcase.
Now, Patrick, unfortunately, our podcast is way too short to answer all the questions that people have. Now, I know you do run seminars and you do weekly radio shows. How can people sign up for these things? How can they show up to your seminar to ask you all the important questions they need to get answered?
Great question, Jason. So they can always go to our website. We have the updated educational workshops there. The website is elderlawcare.com, elderlawcare.com, and we list our educational workshops on that website. They can also call our Elder Law Care Center, Ryan, Ashley, or Cheryl, or Shannon. Any member of our team can certainly help them sign them up, register them for an upcoming workshop. We typically teach that educational workshop about 4 times per month in the community. And so we teach it out there. We go Facebook Live as well. So no excuses, folks. If you can't physically make it to the workshop, in my opinion, it's always a better way to learn, because you'll get handouts at the workshop, and you'll learn not just intellectually at the workshop, but you'll learn emotionally as well. They say when you learn in those 2 different modes, intellectually and emotionally, it'll be a better chance of you retaining the information, and it'll help you take that action to protect the people you love the most. But if you can't attend in person, by all means, go to Patrick Kelleher's Facebook page, Patrick Kelleher, I think it's 94, and you'll see me there. And just log in and just click on Facebook, and you can watch the event live on Facebook.
Fantastic. Well, Patrick, thanks for coming on. I really appreciate your time, and I hope to have you back again soon.
Jason, my pleasure. Great to see you as always. And you, sir, keep up the good work in the community that you do.
Thank you. Take care.
Thank you.